Welcome back, learners. In this session, we will be discussing on Block 2 Tribal Policies and Legislations, and from the same unit, Constitutional Provisions and Acts for Tribals. Let us see what is the rationale for special provisions for scheduled tribes. The reservation or affirmative action is usually defined as that measure which is aimed at minimizing, if not doing away, with the discrimination and deprivation. The rationale for providing representation to the scheduled caste and scheduled tribes in educational, professional, and political institution was clearly spelt out by Dr. B.R. Ambedkar. The social order has envisaged, which was based on the principles of equality, liberty and fraternity. The India of his dream was with the social order without any discrimination against anyone. Let us see what are the service safeguards for the scheduled tribes. Article 16(4) empowers the state to make provision for the reservation in appointments or posts in favor of any backward class of citizens, which in the state's opinion is not adequately represented in the services under the state. Article 16(4)(a) provides the state from making provision for reservation in matters of promotion to any class or classes of post in the services under the state in favor of the SCs and STs, which in the state's opinion are not adequately represented in the services under the state. Article 335 makes provision for the claims of the members of the SCs and STs in consistency with the maintenance of efficiency of administration in the making of appointments to services and posts in connection with the affairs of the union or of a state. Article 324 provides that nothing in clause 3 shall require a public service commission to be consulted as respects the manner in which any provision under Article 16(4) and 16(4)(a) may be made or the manner in which effect may be given to the provisions of Article 335. Now let us see what are the articles related to protection of women. Article 14 of the Indian Constitution clearly grants equality between men and women, making it obligatory for the state to undertake steps to remove disabilities which women suffer. However, these steps have been taken in various planned periods in order to empower them. The 73rd Constitutional Amendment has special attention on women. It has granted 33% reservation in the three-tier system so as to empower them. Besides, rural development programs like IRDP, TRISOM, NREP, RLEGP, DWACRA, etc., all meant for the rural women. These have emphasized more on tribals, as most of these programs have been functioning in tribal areas, and most of these programs are now merged into the flagship national programs. Now let us see what are the legal measures for the protection of the rights of the scheduled tribes. There are two important legal measures for the protection of rights of scheduled tribes, which can be identified as the SCs and STs. That is the Prevention of Atrocities Act 1989, which came into force from January 1990, and the Constitution of the National Commission for Scheduled Tribes, which was established in the year 1990 with wide-ranging powers and functions. The Statement of Objectives in the SC and ST Act of 1989 spells out the reasons behind the introduction of this act. Despite various measures to improve the socio-economic conditions of the scheduled caste and scheduled tribes, still they remain vulnerable. They are denied civil rights. They are subjected to various offences, indignities, humiliation and harassment. They have in several brutal incidents been deprived of their life and property. Serious crimes are committed against them for various historical, social and economic reasons. The National Commission for SCs and STs was constituted to protect their rights from being violated. In the year 2003, the National Commission for SCs and STs was split, and the National Commission for SCs and the National Commission for STs were created precisely to give specific orientation and emphasis to the issues of the SCs and STs. The legal measures are in conformity with safeguarding the interests of weaker sections. Now let us see what are the human rights dimension in Indian Constitution. Human rights refer to the basic rights and freedom to which all humans are entitled. Examples of right and freedom which have come to be commonly thought of as human rights include civil and political rights such as the right to life and liberty, freedom of expression and equality before the law, and economic, social and cultural rights including the right to participate in culture and the right to food, the right to work and the right to education. Article 1 of the United Nations Universal Declaration of Human Rights also states all human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. The Indian Constitution has also made such provisions in its constitutional articles, fundamental rights and directive principles of state policy. The government also intends to protect these rights through various acts. In the state level, the governor has been given the role of protecting people's constitutional as well as human rights. Right to Information Act was also passed in 2005, and before this the Scheduled Tribes Prevention of Atrocities Act 1989 was passed. So all these are meant to protect the human rights of people, including those of the scheduled tribes. Now let us look at what is the rationale of the acts for scheduled tribes. The overall goal of the Constitution of India is to promote equality, justice and dignity for every citizen. It aims to protect and safeguard the interest of scheduled tribes. And it is this end that legislation have been enacted in all those states that have been inhabited by the tribals. Such acts have been already there are in some parts of India since the time of the British regime. In the post-colonial India, however, legislations have been enacted to ensure rights, dignity and justice to tribals. Their preservation, protection and promotion are also facilitated by special administration of the tribal areas referred to the 5th and 6th scheduled areas. The Constitution Act 1951 gave the state the directives nothing shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste and scheduled tribes. The Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989, which came into effect from January 1990, is one of the landmark in evolving a mechanism to ensure the protection of STs and SCs. This act clearly and categorically spells out the measures for preventing atrocities, setting up special courts for speedy trial and stringent punishments for those violating the rights of weaker sections. The Constitution provided the appointment of a special officer under Article 338(1) of the Constitution to investigate all matters relating to the safeguards provided for SCs and STs and report to the President about the working of such safeguards. The office of the special officer, subsequently designated as a commissioner for SCs and STs, came into being on 18 November 1950. By 1965, its 17 regional field offices had been set up in different states to oversee the functioning of the various safeguards. This single member office was done away with and a multi-member commission was constituted. The first commission was set up in August 1978 with Sri Bola Paswan Shastri as chairman and 4 members were there. The Constitution Act 1990 was notified on 8 June 1990. The first commission under the 65th Constitutional Amendment was formed on 12 March 1992 with Sri Ramdan as chairman, replacing the commissioner for SCs and STs, and the commission was set up under the resolution of 1987. From that time onwards, 4 commissions functioned. Now let us see what are the Scheduled Caste and Scheduled Tribes Act 1989. The Scheduled Caste and the Scheduled Tribes Prevention of Atrocities Act was promulgated mainly to prevent the offences of atrocities against the members of the SCs and STs, to provide for special courts for the trial of such offences and for the relief and rehabilitation of the victims of such offences. The important aspect of this act is that the punishment for committing atrocities on STs and SCs is applicable to anyone who is not a member of SC or ST. Some of the areas of atrocities on STs and SCs demanding a stringent punishment are dehumanizing treatment or humiliation, false accusation, false information, forced dispossession, physical torture, deprivation of rights, destruction of property, forced labor, legal and administrative negligence. So, let us discuss all these in detail. Firstly, we will see related to dehumanizing treatment or what kind of humiliation happens to a SC or ST. For example, forcing a member of scheduled caste or scheduled tribe to drink or eat any inedible or obnoxious substance. Acts with intent to cause injury, insult or annoyance to any member of SC or ST by dumping excreta, waste matter, carcasses or any other obnoxious substance in his premises or neighborhood. Forcibly removing clothes from the person of a member of SC or ST or parading him naked or with painted face or body or committing any similar act which is derogatory to human dignity. Nextly, false accusation, instituting false, malicious or vexatious suit or criminal or other legal proceedings against a member of SC or ST. Giving or fabricating false evidence intending thereby to cause any member of SC or ST to be convicted to an offence which is capital by the law. Giving or fabricating false evidence intending thereby to cause any member of SC or ST to be convicted of an offence which is not capital but punishable with imprisonment for a term of 7 years or upwards. Then moving on to the false information. Giving any false or frivolous information to any public servant and thereby causing such public servant to use his lawful power to the injury or annoyance of a member of SC or ST. Then let us see regarding forced dispossession. Wrongfully occupying or cultivating any land owned by or allotted to or notified by any competent authority to be allotted to a member of SC or ST or getting the land allotted to him transferred. Wrongly dispossessing a member of a SC or ST from his land or premises or interfering with the enjoyment of his rights over any land, premises or water. Forcing or causing a member of SC or ST to leave his house, village or other place of residence. Now, let us see what are the physical torture given to SC or ST. Assaulting or using force to any woman belonging to SC or ST with intent to dishonor or outrage her modesty. Being in a position to dominate the will of women belonging to SC or ST and using that position to exploit her sexually, to which she would not have otherwise agreed. Then let us see what are the deprivation of rights. Forcing or intimidating a member of SC or ST not to vote or vote to a particular candidate or to vote in a manner other than provided by law. Contaminating the water of any spring, reservoir or any other source ordinarily used by members of SC or ST so as to render it less fit for the purpose for which it is ordinarily used. Denying a member of SC or ST any customary right of passage to a place of public resort or obstructing such member so as to prevent him from using or having access to a place of public resort to which other members of public or any section thereof have a right to use or access to. Now, let us see what are the destruction of property to them. Committing mischief by fire or any explosive substance intending to cause or knowing it to be likely that he will thereby cause damage to any property belonging to a member of SC or ST. Next, forced labor. Compelling or enticing a member of SC or ST to do beggar or other similar forms of forced or bonded laborer other than any compulsory service for public purposes imposed by government. Then moving on to legal administrative negligence. Here Committing any offence under the Indian Penal Code 45 of 1860, punishable with imprisonment for a term of 10 years or more against a person or property on the ground that such person is a member of SC or ST or such property belongs to such member, shall be punishable with imprisonment for life and with fine. So, knowingly or having reason to believe that an offence has been committed under this chapter causes any evidence of the commission of that offence to disappear with the intention of screening the offender from legal punishment, or with that intention gives any information respecting the offence which he knows or believes to be false, shall be punishable with the punishment provided for that offence. Being a public servant, committing any offence under this section shall be punishable with imprisonment for a term which shall not be less than 1 year, but which may extend to the punishment provided for that offence. Wilfully neglecting of duties by a public servant required to be performed by him who is not a member of the SC or ST, resulting in the harm of STs and SCs. Now, after discussing all this, let's move on to the provisions of the Panchayat's extension to the Scheduled Areas Act 1996. So, this is also known as PESA Act, came into effect on 24 December 1996. The notion behind this act was to extend the 73rd Constitutional Amendment of 1993 to the scheduled areas so as to enable tribal society to assume control over their own destiny, to preserve and conserve their traditional rights over natural resources. Hence, this act can be called the modified version of the amendment. This act is also applicable for all the states except Meghalaya, Tripura and Mizoram, which come under the 6th schedule of the Constitution. This recognizes the prevailing traditional practices and customary laws of the local people, besides management and conservation of natural resources through Gram Panchayat. Patnaik in the year 2007, he says that it decentralized existing approaches to forest governance by bringing the Gram Sabha to center stage and recognize the traditional rights of tribals over community resources, that is the land, water and forest. PESA was important not just because it provided for a wide range of rights and privileges, but also because it provided a principle as well as a basis for future law making concerning the tribals. This act encourages the organization of people through Gram Sabha and state. It empowers the Gram Sabha to approve the plans, programs and projects for social and economic development before they are taken up for implementation by the village panchayat, to identify beneficiaries of poverty alleviation programs, and also to give certification of utilization of funds by the panchayats for the above programs. These powers make the Gram Sabha a powerful body in implementation of projects for social and economic development of tribal communities. It also recommends consultation of the concerned authority in the matter of land alienation and land transfer, as is the authority with the recommendatory power. The Act also stipulates the states to endow panchayats with such powers and authority so as to work within the institutions of self-governance. This also paves the way for the state level Panchayat Raj Act. The rationale of this exercise to convert the tribal villages into small units of self-rule. The new act, with all its limitations, seems to be the last chance of democratizing governance and decentralizing power in an effort to encourage the notion of development amenable to local social and cultural sensitivities. The idea for self-rule by tribes has an inherent philosophy that subjects themselves as subjects can achieve their own development and not as objects has been the case all along. A review of the constitutional provisions gives an insight into the framework for tribal welfare, protection and development. Of these, the provisions in Article 244 and 244A under Part 10 of the Constitution have some implications for the expression of self-rule among tribes. The fifth schedule, Article 244(1), has provisions for the administration and control of scheduled areas and scheduled tribes. The sixth schedule, Article 244(2) and 275(1), has provisions for the administration of tribal areas in the states of Assam, Meghalaya, Tripura and Mizoram. Tribal self-rule today can be best described in the PESA Act 1996. Sharma, in the year 1997, he explains how the tide has turned in favor of the people since the Gram Sabha has been made supreme and the state supremacy has been challenged. But the success of the new act, it will be gauged only if it addresses issues of indebtedness, land alienation, poverty, alcoholism, illiteracy, housing, deforestation, industrialization, unemployment, migration, lack of openness and exploitation. Now moving on to the prospects of PESA Act 1996. It opens up range of prospects for safeguarding and promoting the interest of tribes. Some of the major prospects, let us see what are the prospects. The Act has constitutional mandate and a binding law to put a legal and moral pressure on the government and its machinery to implement it. There is a qualitative change in the very notion of tribal development. There is no more distribution of funds, but there is a paradigm shift which consists in its basic assumption that tribal community is competent to safeguard and preserve their traditions and customs, their culture identity, community resources and the customary mode of dispute resolution. Development is projected as collective. The approval of plans, programs and projects for social and economic development is the responsibility of the entire village. The idea of empowerment is based on the notion of decentralization. The higher levels of panchayats do not interfere with the lower. There is a provision for accountability to monitor all kinds of financial transactions to avoid any irregularities. The funds are available to Gram Sabha as per the need, and for every paisa the panchayat is accountable to Gram Sabha. Gram Sabha is supreme and is endowed with the power to have control over water, minor minerals, drinks, minor forest produce, alienation and restoration of tribal market and over the system of debt. There is recognition of the traditional way of settling disputes. This avoids the bureaucratization of justice. Women empowerment gets a boost as the Act ensures 1/3 of women participation in the panchayat. Now let us look at what are the challenges. The provisions of the Panchayat Act 1996 has within its own inbuilt policy level struggles. There is in the process of empowerment a clash of interests, vested interest at every place, either in bureaucracy and political party or in the village itself, try their best to throttle the process of tribes empowerment. In the political and bureaucratic circles, the stakes are quite high. Provision for direct transactions with government with a view to control exploitation and corruption hits the bureaucrats, politicians, contractors and petty brokers. Hence, non-cooperation from them is not quite unexpected. The experience of Bihar is an eye-opener in this regard. According to a report by Mishra in the year 2002, within 6 months of its existence, after a gap of 23 years, Bihar Panchayat Raj came under attack from bureaucrats and politicians. At Bihata, the BDO allegedly gunned down a Mukhiya. Near Shekhpura, the election of candidates not backed up by a senior Congress leader led to the killing of 9 political workers, including a Mukhiya and a Jilla Parishad member. In Jahanabad, a Pramukh and the BDO were not in talking terms. Nearly in all Panchayat Raj bodies, the elected bodies were at loggerheads with bureaucrats or MLAs and MPs. After the Panchayat Raj elections that year, there were at least 300 killings related to conflicts in such bodies. There were bypolls for over 1,700 Panchayat seats in Bihar, including 104 that of Mukhiyas, mainly due to the killings of the functionaries elected in the Panchayat polls. An analysis of these reporting shows that these are conflicts of interest. A battle between entrenched vested interest and new social forces seem to be emerging at the grassroots. Bureaucrats assumably are uncomfortable about the powers of the panchayat. There is also lack of awareness and understanding among elected functionaries and officials. Antisocial elements are getting elected and politicians are using them. The officials do not want to lose their unquestioned power, and the elected functionaries overreact to their newly acquired status. The polarization and segmentation of village population on the basis of caste, religion and ethnicity defeats the purpose of the people's democracy. The politics of majority, minority and antagonism among various parties will be a hindrance to the development of the village. In the entire country, in general, caste, religious and ethnic tensions are on the rise. The prospects of poll violence, intimidation, booth capturing and bloodbath in some of the sensitive areas cannot be ruled out. The panchayat elections in Bihar after 23 years had the same experience. According to Khan, in the year 2002, the Bihar panchayat elections for 8,452 panchayats held in 6 stages left 100 dead and many injured. At least 588 people with criminal background were elected. Out of 1,30,563 Mukhya posts, criminals occupied more than 500. Police had arrested 40,000 criminals to control violence. The government had appointed 50,000 police and 57,000 home guards. When police refused to go on duty for fear of violence, the government ensured each for 10 lakhs. Within the new Panchayat Act, most villagers, especially tribals, hope that their dreams of a dignified life will be fulfilled. Now let us look at what are the forest dwelling scheduled tribes and recognition of forest rights. The Forest Dwelling Scheduled Tribes and Other Traditional Forest Dwellers Act 2006 is the revised version of the Scheduled Tribes Bill 2005. It emphasized the forest rights of both the tribals and the forest dwelling communities, as the earlier bill ignored the other forest dwelling communities. It extends to all the states except Jammu and Kashmir. It recognized the rights of the STs and forest dwelling communities on forest land that include the protected forest, reserved forest, wildlife sanctuary and national parks. It also recognizes the people whose forest rights can be recorded. It mandates that the forest dwelling communities and other traditional forest dwellers have rights over forest occupied before December 13, 2005. Now let us see how do the tribals view the act. India has a forest cover of only about 13% of the land mass. Majority of the tribals in the country inhabit the forest and they are living from the forest resources. This act overemphasizes on the positivistic jurisprudence while acknowledging individual proprietary rights linked to forest management. Hence, the act from the beginning stresses on regularizing encroached lands in the forest. Allocation of 2.5 hectares of land to every FDSD and TFDs is also opposed to the recognition of corporate and usurpatory rights. To sum up, in this unit, we have discussed the provisions and legislations ensured in the Constitution of India to safeguard the interests of scheduled tribes and to empower them for a life of equality, dignity and justice. Some of the most important acts promulgated for ensuring protection of tribals from atrocities, control over resources and their management, and local governance in scheduled areas and tribal areas. It gives us an insight into the plight of the tribals and a rationale for institutionalized safeguards and to protect them. The relevance of positive discrimination and other legislation in the context of scheduled tribes are also discussed in this unit. So learners, you would have carefully listened to the video and various acts, provisions, legislations related to SCs and STs. Hope to meet you next week. Thank you.